The topic of my talk is on the point of cancellation of bail. The Supreme Court in 1977, the case of Gurcharan versus State and City of Delhi, had ordered the Session Court to expedite the trial within few months and had laid down some guidelines before granting the bail to an accused person. Some parameters have to be checked while granting the bail to an accused person. So the issue before the Supreme Court arises that whether the accused person who is an appellant, whether his bail can be cancelled or set aside by the High Court, the same bail which has been granted by the Session Court in a murder case. So likewise, prior to the enactment of section 1973 of CRPC, this code was first of all passed during the time of British period. So 490A of CRPC then in 1988 during the time of British had various wide power exercising the grant of bail. So this court has referred to that section 498A of Code of Criminal Procedure 1973 and said that the 498A that then passed in 1898 in comparison to section 437 of the new Code of Criminal Procedure is same. Their limitation is same. So the guidelines that has been passed in this case, that the Session Court or the Magistrate Court, whichever is being tried, whichever the offence is being tried by the particular court, they should see the nature of the offence. They should secure the presence of the accused at the trial, the nature of the seriousness of the offence, and whether the accused can tamper with the witnesses or not. All these things have to be considered by the Session Court or the High Court. So the foremost important thing laid down in this case, what at the stage of granting the bail to an accused person, these 4 or 5 factors one has to keep in mind before passing an order of cancellation of bail or granting the bail. So one more thing that was introduced earlier in 1898 Code of Criminal Procedure, that in one of the section the line was that the accused should be brought before the court. That's it. Now in section 437, that in what cases bail may be granted to a person, that says that an accused person who is brought before the court other than the High Court or Session Court. So it does not transpire anything. It does not pose any limitations. It does not create any limitation on the power of the High Court or Session Court in granting of bail. Because we have seen in numerous judgments, the Supreme Court, while dealing with the application of consideration of this cancellation of bail, has reversed in the heinous offences. So it has specifically passed an order to the Session Court, because this Session Court, when at the stage of bail application, they have to keep several factors in mind before granting the bail. The state which has approached the High Court in cancellation of the bail to an accused person, they have 2 remedies. One remedy is that they can challenge the order of the MM before the Session Court by way of revision, or they can go to the court of Session Court or to the Session Judge that several new developments has been made in the case, so it is not likely to give the bail to the accused person involved in these heinous offences. Because section 397, which provides revisional power of the court, it has concurrent power. 397 has concurrent power over the Session Court and the Revisional Court. That's it. Thank you.